Has the legacy media been present? Or do you feel that the legacy media has been paying attention?
There hasn't been substantial coverage of the broader issues here in the context of the constitutional right to freedom of the press, to the state of democracy, to the state of police and Indigenous relations. It hasn't been put in its proper context. And so that's what's a little bit disappointing, because if journalists can't access a space where a major story is unfolding and document and report it, then how are people going to know? And I think we need to be shouting that loud and clear from the rooftops, journalists right across the country.
Everyone has the following fundamental freedoms: freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. That's from Section 2B of the Canadian Charter of Rights and Freedoms. I'm Adrian Harewood, and this is In Bed with the Elephant. The online investigative outlet The Narwhal and the award-winning photojournalist Amber Bracken are suing Canada's National Police Force, the RCMP, for wrongful arrest, wrongful detention, and breach of charter rights, including the right of journalists to gather and report information to the public. Bracken was arrested in November 2021 in northwestern British Columbia and held in custody for 4 days after officers raided a small house she was in, along with a documentary filmmaker working for the CBC and 5 Indigenous land defenders who opposed construction of the Coastal GasLink pipeline on traditional Wet'suwet'en territory. The house had been built in defiance of a court-ordered injunction obtained by the company building the pipeline. Bracken was there covering protests against it. The trial is taking place over 6 weeks in a Vancouver courtroom. The case has become a litmus test for press freedom in Canada. The Bracken and Narwhal suit seeks to hold police to account for interfering with the constitutional rights of journalists. Justin Brake has been closely following the Amber Bracken case. He's been in the BC courtroom observing the trial. The Newfoundland and Labrador-based journalist, editor-in-chief of the online news publication The Independent, knows something about being arrested by the police while doing his job. Back in 2016, Brake was arrested by the RCMP and criminally charged while reporting on Indigenous-led protests in Labrador. He was found guilty, but then cleared on appeal by the Newfoundland and Labrador Supreme Court in a landmark decision now called the Brake precedent that has shaped media interactions with police ever since. Brake has been in the BC courtroom observing the Bracken and Narwhal versus the RCMP trial and recently penned a feature article for the digital news outlet Ricochet.media, in which he talks about what he has seen and what the case is about. Justin Brake, welcome to In Bed with the Elephant.
Thanks for having me, Adrian. It's good to be here.
Justin, maybe you can just give us the backstory so that we know the main players in this Amber Bracken and Narwhal case, the key entities that are at the center of the story, and the critical issues that are at stake. So what is this case about, and how did it come to be?
Well, Amber Bracken is certainly the one at the center of this. She is an award-winning photojournalist who has had her work published in the New York Times, the Globe and Mail, and a host of other reputable publications. She's a veteran, and she is known for covering Indigenous issues, I'll say broadly, but in particular, land defense actions. In most cases, I think over the last number of years, we've seen First Nations take a stand against unwanted industrial development on their land. So in British Columbia, where Amber has multiple times traveled from her hometown where she's based in Edmonton to northern and central BC to cover these stories over the last number of years, she has done some amazing work and won awards for that work. And in particular, we're talking about Wet'suwet'en territory, which is, like most of BC, unceded. And that's really important. It doesn't come up in the case, but to kind of give some context as to the importance of these stories, I mean, we're talking about, the decade of post-Truth and Reconciliation report coming out. We have very specific sort of directives, anecdotes, and ideas about what is necessary for reconciliation. And so what makes these stories of Indigenous people defending their land and their territory and their ways of life against unwanted development is that so much of those activities happening in Indigenous people's territories is contradictory to what the stated goals of the federal government, provincial governments, and other actors are. And so, when journalists go and, quote unquote, embed with Indigenous land defenders or protesters getting involved in these causes, I think journalists who take their work seriously and understand their role in society, especially in Canada in this day and age, they're choosing some of the most important stories. They're making very good editorial decisions when it comes to deciding to cover these stories. And that, unfortunately, these days comes with some risk due to the RCMP's a trend that has kind of unfolded among the RCMP, who often is the police force that ends up dealing with some of these situations. So Amber Bracken is at the center of it. She had been there in Wet'suwet'en territory multiple times before 2021, which is the year she was arrested. But at this particular time, November 2021, we're a year and a half or so after the Wet'suwet'en resistance to the Coastal GasLink pipeline reached a climax, when there were solidarity protests across the country. Railways were shut down. Commerce was brought to a halt. Most people will remember that. That was right around the time that the pandemic began. There has been over a decade of Wet'suwet'en resistance, almost a decade and a half now. And so there have been flashpoints, and Amber happens to have been caught in the middle of one of those flashpoints when she was there covering it.
And she's covering, of course, these protests. People are protesting against the Coastal GasLink pipeline.
Canada's Coastal GasLink liquid natural gas pipeline runs 670 kilometers across British Columbia. The route cuts right through the center of unceded Wet'suwet'en territory. The project has been stalled since blockades popped up, blocking construction on Wet'suwet'en lands. The British Columbia Supreme Court granted Coastal GasLink an injunction, allowing the removal of any blockades along the construction route. The Wet'suwet'en First Nation countered the next day by serving Coastal GasLink with an eviction notice for trespassing.
That's right, the Coastal GasLink pipeline. So that is supposed to carry natural gas from Alberta to the coast in BC. There has been significant resistance in the Wet'suwet'en Nation, and it's not just, a few quote-unquote rogue activists. Like, this is a nation that is still deeply invested and involved with long-standing traditions and customs. And so they have a hereditary government. So Coastal GasLink, the company's had years of interactions with Wet'suwet'en. And basically at this point in time, in the fall of 2021, a decision was undertaken by one of the hereditary leaders named Slaydo, who's also known as Molly Wickham, that her house clan, the Giddenden clan, they were going to enforce the eviction notice. So the area in Wet'suwet'en territory where the pipeline's going, there are towns in the area like Houston and Smithers and stuff, but this is all happening deep in the woods, like 60, 70 kilometers down Forestry Service Road. So they decided in their part of the territory, the house clans have different parts of the territory that are theirs. They set up a tiny house and a camp on a site that was going to be constructed to dig beneath a river so that the pipeline could go beneath the river. And they were doing this to protect the river and to assert their sovereignty.
Okay. And so an injunction is issued, right, by the BC Supreme Court in what, I think it was in 2019?
Yeah, so there's been an injunction in place for quite some time, and it has been used in 2019 and 2020 to arrest land defenders and others who were involved in the protests out there. So what an injunction is I guess anyone can go to a court. In most cases, I think it's Supreme Courts, provincial Supreme Courts, and ask for injunctive relief. They can ask for an order from the court that kind of compels somebody to stop doing an action that is impeding with your rights. So in the case of resource development, we often see companies seek injunctions from the courts by making the argument that protests or land defense actions are disrupting construction and causing financial loss. And the courts historically grant those injunctions. And so what happens then when there's an injunction granted is police, and in most cases with Indigenous communities, the RCMP is the police force of jurisdiction. So police are then compelled to enforce the injunction. So even if you have a senior police officer or cops on the particular team, emergency response team or whatever, who, kind of sympathize with Indigenous people, and, they have to go and enforce that injunction. But there is discretion given to the police about kind of how and when they do that. And a lot of those details are what we've been hearing in court in Vancouver in the Amber Bracken and Narwhal trial.
Right. So this injunction is in place, and Amber Bracken, along with the documentary filmmaker Michael Toledano, and I think it was 5 Indigenous land protectors, are in this structure on the territory on the 19th of November, and the RCMP knock on the door. Can you kind of tell us what happened that day?
Yeah, so this was actually early in the day, and they didn't exactly knock on the door. So this is based on information that I've gathered from testimony at the BC Supreme Court, but also Ricochet and the Independent and the Canadian Association of Journalists applied to obtain all of the exhibits and evidence from the trial, and the judge granted us that. So I've been going through, there's thousands of pages of documents, and I've been going through some of it. So some of this knowledge comes from those documents as well. The plan to carry out the operation after the RCMP says negotiations with Wet'suwet'en had failed, the plan to execute this operation and enforce the injunction was made a few days prior to that day, November 19th, when Amber Bracken and the others who were in that tiny house were arrested. And so we can see through emails, internal RCMP emails, especially the 2 days leading up to it, that officers were being mobilized, strategies were being developed, and plans were being made to enforce it. So by November 18th, they knew that they were going in the following morning. And the night before, or the early in the morning that day, 5 a.m., I think, dozens of officers started making their way down the Forestry Service Road to the Coyote Camp. And so what we can see visually of that enforcement of that operation is footage from Amber Bracken and Michael Toledano, who were inside the tiny house with Slado, Molly Wickham, and a few other land defenders, as those people were getting ready to face not only police, but heavily armed, militarized police with the full camouflage, semi-automatic weapons, and the whole bit.
Get your gun off me! Lower your gun! Get your gun off me!
And so we can see police kind of arriving and walking around and sort of situating themselves to get ready for the operation. At one point, before the police break into the tiny house, a script is read telling people that there's an injunction and that if they don't come out, they'll be arrested. That was what one script had said that was passed around between commanding officers in the lead up to the execution of the operation. But from what I'm seeing, that wasn't exactly what was read. And you'll have to see the story for details because I don't want to misquote anything right now. But basically, nobody came out of the tiny house. So the RCMP went and they broke down the door with an axe. So you see this footage now from inside the tiny house. Most of it's taken by Michael Toledano, who was there shooting the documentary while Amber was mostly taking photos. So you see the video from Michael Toledano of the axe coming through the door, almost like that scene in The Shining. And then a chainsaw coming through the door, which is kind of a very dramatic way to enter a wooden structure. I mean, I use a chainsaw to cut my firewood, but I would never cut into anything that could potentially have metal in it because you can hurt yourself or kill yourself or others, right? So it was very unusual and dramatic. And what they did, they arrested people without incident. You see cops come into the tiny house and they take people out one by one. You're under arrest and they escort the people out. And they do all the land defenders and then they do Amber Bracken. And at the moment that a police officer is telling Amber Bracken that she's under arrest, she tells him, "I'm media."
You're under arrest. You're under arrest.
For the record, I'm a member of the media. You've been notified that I'm here. I'm under arrest right now, so step out.
I'm here. I'm on assignment for the Narwhal. She identifies herself. But also, the day before that, November 18th, The RCMP received 2 emails telling the RCMP that Amber Bracken was there. One was from the Narwhal, from Matt Simmons, who I believe was acting editor at the time, informing the RCMP that not only was Amber Bracken in Wet'suwet'en territory covering it, but that she was specifically at Coyote Camp. Also, the CAJ, Brent Jolly, the president of the Canadian Association of Journalists, also emailed the RCMP and said that he had concerns because the day prior, documentary filmmaker Melissa Cox had been arrested by the RCMP in another operation on a bridge leading up to this site where they had arrested land defenders. They also arrested Melissa Cox, but then let her go.
So we know that the RCMP received these emails from the CAJ, the Canadian Association of Journalists, and also from the Narwhal. Do we know that they read those emails?
We know that the RCMP read the emails, but the most important person at the RCMP to have read the emails says that he doesn't remember when he read them, but it looks like it was after Amber Bracken's arrest. So what happened was the RCMP communications people immediately forwarded those emails to John Brewer, who is now an assistant commissioner with the RCMP in BC. And at the time, he was a veteran of the Community Industry Response Group. That's the controversial unit that is responsible for executing these operations and enforcing injunctions. And he was the gold commander of the Community Industry Response Group, which for short, we call it CIRG. He was the one who was forwarded the emails, and although he had been opening other emails in his inbox over those periods of hours and few days leading up to the operation, he says he didn't see those emails until after, which hurts the RCMP's argument a little bit because there are multiple things that the RCMP argue they considered in deciding to arrest and then jail for 3 days Amber Bracken and Michael Toledano. That's one thing that we do know. We know that journalists and the media outlet that Amber Bracken worked for did their due diligence in terms of informing RCMP that there were journalists on the ground present there, but that wasn't enough to prompt the RCMP to not arrest Amber Bracken.
Even if the RCMP had not received or not seen those emails, let's say on time, should they have known that Amber Bracken was a journalist?
Well, they knew Amber Bracken was a journalist. That's been testified in court. Plus, Amber was present when the RCMP was enforcing and the injunction previous to that. So they knew Amber Bracken was a journalist, although John Brewer at one point in his testimony said he wouldn't know even today what she looks like, as she's literally sitting in the courtroom watching him say this. What's really interesting about this trial is that the lawyers on both sides are relying heavily on a 2019 decision from the Newfoundland and Labrador Court of Appeal. In my case, after I was charged civilly and criminally for covering the Indigenous-led occupation of the Muskrat Falls hydroelectric project in Labrador in 2016.
That multi-billion-dollar hydroelectric project.
Oh yeah, huge. It's somewhere up like $12-15 billion, and the people of the province are paying for that still today. That court case, which was made by the Newfoundland and Labrador Court of Appeal in 2019, basically absolved me of, any criminal or civil liability for just being there and reporting the story. And in the decision from the appeal court, authored by one of the 3 judges who sat on that panel, they say that journalists covering important protests, especially if it involves Indigenous people, their rights need to be considered, or their status, their special standing as a journalist needs to be considered when, in this case, it was a Crown corporation, when parties go to the court seeking injunctive relief, you can't just neglect to mention that there are journalists there without notifying the court. And of course, the police would then be made aware if they weren't already. And so the authoring judge of the decision, Justice Derek Green, said, he offered, for a first time in Canadian law, a list of considerations that could inform parties in the court as to when it would be appropriate to regard the presence of a journalist in a protest as a material fact to be disclosed to the court. So he basically sets out these 5 criteria, which are now, I'm hearing, interestingly, in the Amber Bracken and Narwhal RCMP trial, are being referred to as the break factors or the break criteria. And number one is that the person in question is engaged in apparent good faith in a news gathering activity of a journalistic nature. He or she is not actively assisting, participating with, or advocating for the protesters about whom the reports are being made. Number three was the journalist does no act that could reasonably be considered as aiding or abetting the protesters in their protest actions or in breaching any order that has been already made. Number four, he or she is not otherwise obstructing or interfering with those seeking to enforce the law or any order that has already been made, or is not otherwise interfering with the administration of justice. And number five is the matters being reported on are matters that can broadly be said to be matters of public interest. Particular consideration should be given to protests involving Aboriginal issues.
And yet, Justin, Amber Bracken was charged with aiding and abetting these protesters. Is that not the case?
4 years ago, the RCMP arrested Amber Bracken while she was on assignment for the Narwhal. Amber carried a letter of assignment in her pocket. She wore visible press tags and carried multiple cameras. She verbally identified herself as a journalist. And none of this apparently mattered to the RCMP as they took her gear, placed her under arrest, charged her and imprisoned her for 3 days.
She's been accused by the RCMP of aiding and abetting. It was in an RCMP response to the original filings to the BC Supreme Court in 2023 that the RCMP's position then, long before the trial began, was that Amber was aiding and abetting the protesters. Of course, there was no evidence produced then, and to my knowledge, there's been no evidence produced that that's the case in this whole trial so far.
So those charges, though, because she was charged, those charges were dropped.
They were dropped, but the point is the damage had been done. By arresting and jailing Amber Bracken for 3 days, they ended her reporting of that land defense and the police enforcement of the injunction. And this also just adds to the already existing, growing, chilling effect on journalists and newsrooms who may be wanting to send a reporter to report these stories. If they know there's a chance of arrest, well, it's a very expensive endeavor to defend yourself in court and have to go through a lengthy legal process. But we're lucky in this case that even though the charges were thrown out against Amber, they decided to sue the RCMP for their actions. And in making that decision, they're not just defending themselves or trying to protect their own interests. This could set a legal precedent that will benefit journalists, and through journalists, the entire public who has a right to know about, among many things, how the RCMP deals with Indigenous people in 2026 and beyond.
I should state for the record that I am currently on the board of the Narwhal and have been for a couple of years. Why is this case then so important for the future of press freedom in Canada?
We see in emails and from briefing notes that they were told that, we have to make sure that if somebody identifies as media, that's fine. It's not our job to determine who's a journalist and who's not, but we have to consider these things. And we also need to, most importantly, I think the thing that we hear about the most in our CMP testimony from the trial is that they were really focusing on the actions of the individual, not about whether they were an accredited or credible journalist or media, but on their actions. And so from what I've heard so far in this trial, which is not over yet, the RCMP's main argument through testimony coming through John Brewer is that Amber Bracken was arrested because she did not identify herself as a journalist when they had surrounded the cabin and made an announcement and given people an opportunity to identify themselves or come out or whatever. So Amber's inside the cabin, which I believe was locked. I think that's why they had to go through it with an axe and a chainsaw. And if that's me as a journalist, I'm not leaving. I've got my cameras on the people standing there. I'm going to be a little bit nervous about opening a door where there's a good likelihood that multiple guns are pointed at me, right? Especially with a big camera in my hand. I don't know what Amber's reason for not opening the door was. She may have testified to that in court, but I don't recall hearing that. But the point is, that was the RCMP's main argument because she didn't come out and identify herself when she had a chance to.
So they're contending that had she identified herself, she would not have been arrested.
she may not have been arrested. I don't know if they say outright that she wouldn't have been, but that is the main justification being used for maintaining her arrest, because other people, including journalists, elders, others have been arrested and then arrested and then released. But they made a decision to put Amber Bracken in jail. And that's a big part of the controversy about this, is that the arrest and initial detention is one thing, but to jail her for 3 nights was completely unusual in Canada. We don't see that happening a lot, and it's a part of a frightening trend.
I wanted to take a moment to thank you for listening to In Bed with the Elephant. If you can, please follow us in the app that you're using. If you already follow us, thank you. And please do take the time to leave a rating or a review. It helps to get more people listening to our show. And please keep spreading the word about us to your networks. In a world drowning in misinformation and disinformation, never has the work of journalists been more important. That's why we here at In Bed with the Elephant are so grateful to our podcast's founding sponsor, Perfect Books, for their support of independent journalism. Perfect Books is an independent bookstore located at 258A Elgin Street in the heart of downtown Ottawa. Perfect Books, a store for book lovers. There's a long and sordid history that involves the RCMP and Indigenous nations. Can you maybe just tell us a little bit about what the relationship between the RCMP and Indigenous nations has been in this country?
Going back to the Northwest Mounted Police, who were effectively used to facilitate colonization of Western Canada and the prairies. The roots of the RCMP are literally in colonialism. But because of changing public opinion about Canada's relationship with Indigenous peoples, in this era of so-called reconciliation, there's been a lot of pressure put on the RCMP to fix a lot of the things that are wrong within the force, including how they police Indigenous communities. They have a long track record of very brutal behavior toward Indigenous people, including facilitating the removal of children to put in residential schools, still today even, sometimes facilitating the removal of children from their families and communities to be put in state care, and in policing protests. It was I was in high school when the Gustafson Lake standoff happened in BC in unceded Secwepemc territory, when the RCMP were caught literally fabricating a narrative to make land defenders and traditional people look bad. We don't have to go back far in history to see how the RCMP treats Indigenous people.
And yet, Justin, the RCMP would say that is history, and that what they were doing in Wet'suwet'en territory, what they were doing was upholding the law, that an injunction had been made, and that it was incumbent upon those people to respect that law. And all they were trying to do was ensure that folks did what they were supposed to do.
Yes, they enforce Canadian law. And as Canada itself has acknowledged, there's overlap and there's big differences between Canadian law and Indigenous laws. It's beneficial if you're one of two parties claiming jurisdiction to a piece of land. It's beneficial to have your court system and your own police force and stuff to make sure that those laws are respected and enforced. And it's obviously to the detriment of the minority group, the subjugated group, perhaps, the colonized group, the group that is living under colonialism, I should say, to not have those means. And so, yes, the RCMP is enforcing Canadian law, but even under Canadian law, when did journalism become a crime, right? And that's what's being argued in court. The RCMP made a deliberate decision to put Amber Bracken behind bars, and that's not acceptable. There's no evidence that she contravened the criteria laid out in the court case, in my case. And at least not that I've seen from the RCMP or from the Crown. It's federal lawyers from the Government of Canada representing the RCMP. And I haven't seen anything or heard of anything that shows that Amber Bracken, who is, a respected professional photojournalist, was aiding and abetting protesters or assisting them, or that she wasn't engaged in good faith news gathering, these kinds of things. And so, Canadian law is is what the RCMP, it could be argued, are violating their own laws. I guess what makes this more appalling is the fact that the Civilian Review and Complaints Commission, which is the oversight body that investigates complaints against the RCMP, has told the RCMP that they have to stop doing this, that they overstepped when they use these broad exclusion zones when they're enforcing an injunction to keep media away. The CRC released a report in 2024, I believe, condemning the RCMP's arrest of Jerome Turner, who was a Gitsan journalist who was on assignment for Ricochet the previous year, 2020, and was arrested at gunpoint by the RCMP. The RCMP offered an official apology to Ricochet, to Ethan Cox, the editor, and to Jerome Turner. And so the RCMP itself acknowledged and admitted that it overstepped. But now in court, more than a year after doing that, Crown attorneys for the federal government representing the RCMP are arguing that the police did not overstep when they arrested and jailed Amber Bracken, and I haven't heard a compelling argument from them. It seems like a very weak case.
I want to get to that, Justin, but it does seem significant that at the time of these events, that the public safety minister, Marco Mendicino, said this. He said that journalists play an essential role in Canada's democracy. Quote, "In order to fulfill that role, journalists must be able to work free from threats, intimidation, or arbitrary state action." And the Crown Indigenous Relations Minister at the time, Mark Miller, who's still a cabinet minister in the Carney government, weighed in on Twitter, writing, quote, "Journalists have a right to cover current events in this country." Are those remarks by those two cabinet ministers of significance?
The significance of them is that they were made in the first place. My case didn't get that kind of attention. It would have been nice to hear leaders from a democratic government saying that press freedom is important to democracy when I was going through the legal process, but we weren't hearing that. You can kind of understand why they didn't address the Amber Bracken case or the RCMP specifically, given that they have to remain free from the judicial branch of government as members of the executive branch and stuff. So they try to keep that line between. But I think it's totally uncontroversial, and if anything, would gain public support for politicians to advocate for press freedom.
It seems to be a rebuke of the RCMP's actions, no?
Yeah, it probably is, but it's, I would say that if there was any significant pressure coming from government, it may have been through other means. The timing of the comments would be, suggest that it's a rebuke of the RCMP, but I think I would have liked to have seen them go further with their comments.
I do want to get to the court case that you've been covering, but I would be remiss if I didn't, reference at least the political economy or a question about political economy, because I'm curious about the relationship, if there is one, between the RCMP and Coastal GasLink.
Of course. Yeah. I mean, broadly speaking, and historically, and even today, the RCMP have been the ones who have displaced or dispossessed Indigenous people from their lands to make way for industrial development and for the building of Canada as a nation. And so that hasn't changed. It's just taken on a different form, and it's obviously less brutal today. But effectively, the RCMP are, and they don't deny this. I mean, the whole purpose of the CIRG, whose name is literally Community Industry Response Group, and they've changed the name because of all the criticism of it and stuff. But it's literally to kind of get in the middle of a conflict when there's conflict between Indigenous people and industry trying to develop on Indigenous lands, when there's conflict, to get in and try to resolve it. And they don't go straight to arrests, as they laid out in testimony in the Vancouver courtroom. They try all kinds of things first. They try negotiations. They try bringing hereditary leaders in for discussions. They do all these things. The last resort of enforcing an injunction with actual force is what they say they do last. What we've learned through this case, and in some reporting prior to this case even, but I think we're getting even more of an insight now, is that there was intelligence sharing between the corporation and the RCMP. They acknowledged that. They got intelligence from Coastal GasLink. about where land defenders were, these kinds of things. Although Jim Brewer, the gold commander for SERG at the time, did testify that if RCMP sometimes doesn't enforce an injunction to the satisfaction of the company that got the injunction from a court, they'll sometimes hear about it, get complaints from the company saying they're not moving quickly enough and things like this. So he didn't say that they got that specific comment from Coastal GasLink, but he said in his experience of enforcing other injunctions, industry will sometimes get impatient and try to pressure the RCMP to move more quickly.
And if you're an RCMP officer, it's pretty lucrative to be part of the community industry response group, is it not? I know that the Capital Daily reported that officers earn up to, $100 an hour, and sometimes work nearly 20-hour shifts.
Yeah, they do make a lot of money. And it should be noted, too, that these are officers who are coming from all over the place. Like, this is not their full-time job because there wouldn't be enough work because these flashpoints don't happen, every day, every week, every month. So they are pulled from their other detachments. They're entering something that is less like a regular policing structure and more like a military structure. The way that commands are given, the structure of the hierarchy of commanders and stuff. And so they're more operating almost like a paramilitary unit in a sense.
This has been a 5-week trial, and you've had the opportunity, obviously, to cover it, but also to be in the courtroom. Tell us what it's been like. Has the legacy media been present? Or do you feel that the legacy media has been paying attention?
They've had a presence there. I mean, CBC and the Canadian Press, and I think the Globe and Mail, a few of them have covered the trial, but it's kind of, drop in for a day, hear what's said, and report on that. There hasn't been substantial coverage of the broader issues here and contextualizing this case in the context of the constitutional right to freedom of the press, to the state of democracy, to the state of police and Indigenous relations. It hasn't been put in its proper context. And so that's what's a little bit disappointing.
What you see, I was going to say that what you seem to be suggesting is that mainstream media outlets in this moment, need to adopt a posture that is the posture of an advocate in order to defend the interests of the need for citizens for, basic information that the press provides.
Exactly. If there was a court case going on right now, a trial going on that could result in the limitation or the restriction of journalists' abilities to, say, go to a courthouse and ask for documentations relating to a court case. If journalists' rights and access to other parts of the justice system were being threatened, I think we'd see more mainstream media being more vocal. But as I said before, and as others have pointed out, because this is seen as specifically an issue related to how journalists cover Indigenous land defense actions, where mainstream journalists seldom go, I'm thinking that newsroom leaders must think that it's not important to join the Narwhal and Ricochet and other media outlets in defending that right for journalists to be there, which is not separate from Canadians' right to know. Because if journalists can't access a space where a major story is unfolding and document and report it, then how are people going to know? And I think we need to be shouting that loud and clear from the rooftops, journalists right across the country.
The case, as you alluded to, resumes on April 9th. Final arguments are expected in early June. Justin, before I let you go, I wanted you to maybe share with our audience 3 books that you would recommend they read.
When I'm reporting on Indigenous-related issues when it comes to resource development, industrial development stuff, there's a few books I often turn to. The book Seeing Red, which I understand is taught in some journalism schools, is a history of Indigenous people in Canadian news coverage. And so, that's a book that I would recommend any journalists or people who want to be media literate when it comes to reading or watching or listening to news that has to do with police and Indigenous people. Anybody should read that book because it really lays out a clear history of media bias in Canada and highlights the media's role in facilitating colonization. And another one, that kind of brings us almost up to the Muskrat Falls period when it comes to policing Indigenous communities is called Policing Indigenous Movements, Dissent and the Security State, which was co-authored by Jeff Monahan and Andrew Crosby. And that lays out sort of some of these early conflicts, Indigenous-led protests against pipelines and stuff. It talks about how the RCMP has responded to these protests. And then you have the last book, which is, I think, would be my number one recommendation. And maybe some of your listeners have read it already. It's been out for like a decade, I think. But if there are any police listening, or government workers, or industrial workers, if you want to understand a really solid perspective of what is going on in Canada today when it comes to Canada's relationship, including the police and industry, with Indigenous peoples, Unsettling Canada by the late Secwepemc leader Art Manuel, is a must-read. It's the one book that I would recommend first for people who want to get an idea about what's really at stake and to get an incredibly informed perspective from one of the most prominent Indigenous leaders in the history of our country. And so it's called Unsettling Canada, a national wake-up call.
Justin Brake, it's very good of you to join us. Thanks so much. You've been listening to In Bed with the Elephant, a production of Ricochet Media. Let us know what you think about our show by leaving a review on Apple Podcasts. You can follow the podcast on Apple, Spotify, Amazon, iHeartRadio, YouTube, or wherever you find your podcasts. The producer and sound engineer of In Bed with the Elephant is Dave Sarrazin. This episode was edited by Sarah Galani. Executive producers Ethan Cox and Andrea Houston. Music, Parker Harewood. I'm Adrian Harewood. See you next time.